So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about new bills coming through the California legislatures that could be affecting California employees and employers. It's a really interesting time to be observing these laws. We'll quickly give an overview, a very basic overview of the structure of California, then move on to each bill and give a wrap up and conclusion. So there is an assembly in the state of California. It's the House of the California Legislature, consisting of 80 members elected for 2-year terms from districts apportioned on the basis of their population. Democrats have a supermajority there, with the current speaker being Democrat Robert Rivas. It's a 3/4 supermajority of 62 seats. Then the upper house is the California State Senate. Each person represents roughly a million people, and the Democratic Party also holds a supermajority there, 32 out of the 40 seats. Generally speaking, whoever authors the bill, that's where the bill starts out and then is passed to the other for approval. If both houses approve the bill, then it goes to the governor. The governor has three choices: sign it, allow it to become law without signature, or veto. Veto can be overridden by 2/3 of vote in both the houses, and generally speaking, any of these bills would go into effect on the first day of January of the following year. First one up is Assembly Bill AB 518. Employees that work in the state of California already can apply for wage replacement benefits from the state to take time off for certain family care related events. And it's generally called paid family leave. But Assembly Bill 518 adds benefits for time off care for designated persons, which are the equivalent of family relationships. The bill defines designated person as to mean any individual related by blood or whose association with the employee is an equivalent to a family member. The bill would authorize the employee to identify the designated person when they file a claim for benefits. I get the impression that this could be very heavily abused, but for those who have multi-generational households or other forms of family that are not necessarily established by law, this can be very valuable. It can be a good resource for them to be able to take care of them in need. And I think that this is an interesting change. I worry about the nature of the abuse that could come from this. But at least as far as I can tell, employers of California will not be footing this bill. The people of California will be, and that is at least one development that helps. That bill has passed in the Assembly and it's currently pending in the Senate. So it's, of course, with the supermajority, it's likely to be passed, but there could be some time where it's debated. Next one up is Bill AB 1076. It was going to make it unlawful to include non-compete clauses in California employment contracts. If a California employee has previously signed one, this bill would require the employer to notify the employee that the agreement is void. This one is sweeping the country right now. I think that non-compete agreements will be mostly a thing of the past within the next 2 to 3 years, and it's not surprising to see it out of the assembly. And frankly, to some degree at least, this is a long time coming. Non-competes are silly restraints on business, and frankly, pretty frustrating. I think non-disclosure agreements should still have some power, in my opinion, but non-competes are not particularly useful, nor do they make sense. The next up is Senate Bill 525, Healthcare Workers Minimum Wage. It is sort of basic. It's requiring a minimum wage of $21 for workers in the healthcare industry starting in June of 2024. And then in June of 2025, it moves to $25 an hour. And exempt employees must be paid no less than 150% of the healthcare minimum wage. It does cover most healthcare operations, but for some reason it doesn't include independent practices, most likely because it would kill the independent practices. I would be curious as to how they define healthcare workers, but I ultimately don't know if this one matters. I guess I'd have to find out who they're defining as healthcare workers, but I imagine that in much of California, $25 an hour, $21 an hour is fairly common. But regardless, what this will ultimately mean is more expenses passed down to the consumer. I never understand these specifics, right? Why healthcare? Why not all? Why one? Why not? But regardless, it does appear that this one has passed in the Senate, pending in the Assembly, and will likely be passed in the near future. The next one up is Senate Bill 700 with marijuana protections. And Senate Bill 700 prohibits employers from asking employees questions about marijuana use. Also, it restricts consideration of prior marijuana related convictions. For some reason, this doesn't apply to employees in the building and construction trade. Of course, I'm sure that the concern is safety, but what about in healthcare? What about in manufacturing, among others? I never understand these specific questions or specific restrictions on these things. But anyway, this bill, it seems to make sense. I mean, I would prefer it to be broader. I think that it's important to simply not discriminate on the basis of anything outside of work as a term or condition of employment. But I think that's just a best practice, not necessarily something that needs to be put into law. The next one up I find incredibly interesting. It's called Work from Home Rights. It's Senate Bill 731, and it makes employers give at least 30 days notice before asking an employee to return to work at the company's premises. And then the notice has to inform the employee of a right to request working remotely as a reasonable accommodation for a disability. Now, let's be clear here. Almost under no circumstances is the request to work remotely a reasonable accommodation for a disability. That's not supported by the Americans with Disabilities Act. I don't think that that's supported anywhere in California, and that has been a really, very difficult trouble to overcome in the HR sphere. There's a few other bills that are coming through. Reproductive loss leave, which allows a employee to take a 5-day leave of absence for reproductive loss, a paid sick leave expansion, workplace violence prevention. There's quite a few. Overall, I don't think that these will have too big of a impact on businesses in California. They seem to be mostly, relatively sensical. They make sense, and it won't be too disruptive to the businesses in California from the year to come. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.